So now Unit 4 Judiciary. In this we are going to see about organization and composition of Judiciary, constitution, appointment and qualifications, powers and functions of the Supreme Court, High Courts, control over subordinate courts. Organization and composition of Judiciary. Many times courts are seen only as arbitrators in disputes between individuals or private parties. But judiciary performs some political functions also. Judiciary is an important organ of the government. The Supreme Court of India is in fact one of the very powerful courts in the world. Right from 1950, the judiciary has played an important role in interpreting and in protecting the constitution. Why do we need an independent judiciary? All disputes must be settled by an independent body in accordance with the principle of rule of law. This idea of rule of law implies that all individuals, rich and poor, men or women, forward or backward caste, are subjected to the same law. The principal role of the judiciary is to protect rule of law and ensure supremacy of law. It safeguards rights of the individual, settles disputes in accordance with the law, and ensures that democracy does not give way to individual or group dictatorship. Next, independence of the judiciary. The other organs of the government like the executive and legislative must not restrain the functioning of the judiciary in such a way that it is unable to do justice. The other organs of the government should not interfere with the decisions of the judiciary. Judges must be able to perform their functions without fear or favor. Judiciary is a part of the democratic political structure of the country. How can the independence of judiciary can be provided and protected? The Indian Constitution has ensured the independence of the judiciary through a number of measures. The legislature is not involved in the process of appointment of the judges. In order to be appointed as a judge, a person must have experience as a lawyer and or must be well versed in the law. The judges have a fixed tenure. They hold office till reaching the age of retirement. Only in exceptional cases judges may be removed, but otherwise they have security of tenure. Security of tenure ensures that judges could function without fear or favor. The Constitution prescribes a very difficult procedure for removal of judges. The judiciary is not financially dependent on either the executive or legislature. The Constitution provides that the salaries and allowances of the judges are not subjected to the approval of the legislature. The judiciary has the power of penalties those who are found guilty of the contempt of court. This authority of the court is seen as an effective protection to the judges from unfair criticism. Next, Constitution. So, composition. Art 124 of the Constitution provides that there shall be Supreme Court of India with consisting of Chief Justice and 7 judges. Further, it says Parliament by law may increase the number of judges. The Supreme Court of present comprises 25 judges, including Chief Justice in India. Appointment of judges. Article 124(2) provides the judge of Supreme Court shall be appointed by the President of India after consultation with the judges of Supreme Court and of the High Courts. In case of Chief Justice appointment, the President may not consult other judges. After 1993 Supreme Court decision, it is now convention that senior most judge of Supreme Court becomes Chief Justice of India and of the High Court. Qualification for appointment of judges. He must be a citizen of India. He has been judge of a High Court for at least 5 years continuously, or he has been an advocate of High Court for at least 10 years continuously, or he is in the opinion of the President of India in a distinguished jurist. Tenure. A person continues as judge of Supreme Court during his good behavior or till he attains 65 years, whichever is earlier. Removal. Under Article 124A, Supreme Court judges can be removed on grounds of misbehavior or incapacity only. The procedure to remove a judge is called impeachment. Any house can initiate impeachment motion, and if it is passed by 3/2 of majority in each house, the judge will be removed. And immunities. Action and decisions of the judges in their official capacity are immune from criticism. Under Article 121, conduct of Supreme Court judge cannot be questioned in a parliament. Next one, appointment qualifications. Next, appointment of judges. The appointment of judges has never been free from political controversy. It is a part of the political process. It makes a difference who serves in the Supreme Court or High Court. As far as the appointment of the Chief Justice in India is concerned, over the years, a convention had developed whereby the senior most judge of the Supreme Court was appointed as the Chief Justice of India. Other judges of the Supreme Court and High Court are appointed by the President after consulting the CJI. Then took it to the view that the opinion of the Chief Justice must be followed by the President. Finally, the Supreme Court has come up with a novel procedure. It has suggested that the Chief Justice should recommend names of persons to be appointed in consultation with the four senior most judges of the court. The removal of judges of the Supreme Court and the High Court is also extremely difficult. A judge of the Supreme Court or High Court can be removed only on the ground of proven misbehavior or incapacity. A motion containing the charges against the judge must be approved by special majority in both houses of the Parliament. Structure of the judiciary. A single integrated judicial system. This means that unlike some other federal countries of the world, India does not have separate state courts. Next, Supreme Court of India, High Court, District Court and other courts, subordinate courts. In Supreme Court of India, the decisions are binding on all courts, can transfer judges of high courts, can move cases from any court to itself, can transfer court from one high court to another. And jurisdiction of Supreme Court. This is the structure of the jurisdiction. Next, judicial activism. In 1980s, weakening of Congress rule, increased regional politics, growing corruption and criminalization, decline of parliament, etc. The welfare state was failing to deliver promises. Parliament and the executive were lacking the will and efficiency, difficult to implement public policies. Judicial activism. The SC started looking into issues related to poverty, public service, corruption, right to Dalits, Adivasis women and children, environmental protection, labor problems, etc. This was done through the mechanism of public interest litigation. Next, judiciary and rights. First, it can restore fundamental rights by issuing rights of habeas corpus, mandamus, etc. The high courts also have the power to issue such rights. Perhaps the most important power of the Supreme Court is the power of judicial review. Judiciary and Parliament. The court has been active in seeking to prevent the superversion of the Constitution through political practice. Many insurance assist directions given to executive agencies, that is, administration of judiciary. And during the period 1967 and 1973, the controversy became very serious. Apart from land reform laws enforcing preventive detention, laws governing reservation in jobs, regulations securing private property for public purposes, functions and powers of Supreme Court, original jurisdiction, right jurisdiction, appellate jurisdiction, appeal by special leave, advisory jurisdiction, court of record. Next, subordinate courts, that is other courts, appointment of district judges, validation of appointments of judgment, etc., recruitment of person other than district judges to the judicial service, control over subordinate courts, interpretation. Thank you.